All right, let me get to my guest here, ladies and gents. Go back to the topic of oil. Jeff Reynolds, oil, gas, environmental attorney. How are you, sir? It's good to have you.
Doing fine.
You've been listening to all of this, and now you're not representing anybody right now.
I am not.
In this,
I have represented a lot of oil companies through the years, but I'm not representing anybody in the massive amount of lawsuits that have been filed so far.
I got you.
I'm here just speaking for myself.
The people who own the drilling rig, I believe it's Transocean.
Yes, sir.
Now, they have recently said that their liability is limited to something like $26.7 million, and they're basing on that on a law from 1851, which is the Ship Owners Liability Act. Is that drilling rig a ship legally, or is it a drilling rig legally?
All right,
and
good question.
Good question. That's a great question. I've looked into that lawsuit, which was frankly a brilliant move on their part. I thought Transocean, who may bear the brunt of the responsibility here. And what their lawsuit filed in Houston says is, under the Limitation of Liability Act, the limit of our liability is A, the value of the rig, which is, they say, is zero because it's at the bottom of the ocean, plus the freight that was on the rig, which they value at about $26 million. And so they have gotten a judge there, a federal judge, to issue an order saying, if you've got a claim against Transocean, come to this court, enjoining other lawsuits from proceeding against Transocean. So that is very interesting. Obviously, to me, there are a lot of questions about that. One obvious one is, do you value the price of the rig now that it's on the ocean floor, or what it was worth before it sunk?
Well, even if you do, prior to sinking, still that's a pretty level cap there. I mean, a conservative cap.
$650 million.
I've heard it's my news has been it's $350 million.
$350
was the value of the rig before it sank.